Hi everyone. In this part of the video, let's cover what is Article 14. Okay. In previous part of the previous videos, we had covered Article 12, Article 13, and basic features of fundamental rights. Okay, where Article 12 defined the definition of states, and Article 13 defines about the laws which can be declared unconstitutional. In this in this part of the video, let's study about Article 14. So, what is Article 14? The state shall not deny any person equality before law and equal protection of law within the territory of India. So it defines about two things: equality before law and equal protection of law. So what is equality before law? What does it say? So equality before law, it says that absence of special privileges to any person, whether you are rich or poor, whether you are president or vice president, all the persons are same before law. Okay, no one is above the law, and the laws are equally subjected to all the citizens. So no one is above law, so there is no reasonable classification, and this equality before law is derived from United Kingdoms. Okay, according to rule of law. Remember, understand, like, what is equality before law? Whether a person A and B both are the citizen of India, or any person, both of them are equal before law. If B is a farmer, A is a prime minister, both of them is equal before law. Okay, so this equality before law was derived from rule of law from UK. Okay, it was proposed by a person called Dicey. Okay, so what is rule of law? What does it say? It says that no person can be punished except by breach of law. If person A does not commit any crime or any act that won't be against any law, then he can't be arrested. Okay, he can't be punished. And equal subjection of laws to all the citizens. If A, B, C are three persons, then the law is equally subjected to all the three persons. Okay, constitution is a result of rights given to an individual. This is not applicable to the Indian Constitution. Remember, okay, this is not applicable to Indian Constitution, since in India Constitution act as a source for individual rights. It acts as a source for individual rights, for fundamental rights. Okay, this is with respect to rule of law, and from which equality before law is derived. So it provides certain negative concepts, such as if a 12-year-old commits a crime, suppose any theft, and if 32-year-old commits a crime, both can't be treated samely, right? They can't be treated same. So for in that situations, we have equal protection of law. Okay, in that situation we have equal protection of law. What is equal protection? Similar treatment under similar situation. Okay, if there are two persons A and B, both persons are of above minors, that is, both person is above 18 years, then both the persons can be convicted for any crime committed by them equally, provided they should have same conditions. If A is something like he is occupying higher constitutional post and B is some farmer, they can't be treated equal. Okay, so reasonable classification will be provided. If a law is made for reservation of women and children in a bus seat, okay, this law can't apply for men and women, so reasonable classification is there. So similar treatment, all the men will be treated in the bus like same like seating arrangement, okay, with similar situations. Okay, but men and women can't be taken like simultaneously for the consideration, where like, why can't men sit in the women seats, like that. Okay, similar application of same laws under similar condition, as we discussed above. Okay, like should be treated alike without any discrimination. Same person should be treated similarly, and the unequals should be treated based on the situations differently. Okay, so the main thing of equal protection of law, which is derived from USA. Okay, let me explain clearly now. Why equal protection of law? This law, like the main disadvantage of equality before law, as we discussed previously, okay, is that all the person are equal in a country, all person, union of all. But this law provides for like reasonable classification. It provides for reasonable classification. As I said, if person A is 10 years and if person B is 40 years, if both commit a crime, they can't be treated equally as according to equality before law. Hence, here comes equal protection of law, where 10 year is given different punishment and 40-year-old is given different punishment. So, and hence reasonable classification is allowed by this law, provided the classification should not be arbitrary. If judge should not feel that 10 years old is his son or his grandson, and he should provide reasonable classification. It should not be done. It should have substantial differentiation. Okay, the differentiation, the reason should be visible. So this is with respect to Article 14. So there are certain exceptions to the Article 14. What are the exceptions? Exceptions are that the president and governor will have special benefits. Okay, what are the benefits? Okay, the president and governor are immune, like, from any proceedings of the court. They are not liable. They are not liable to any court for any actions taken by them in their official capacity. For any actions taken by them during the term of their office, they are not liable to any court. And the second is, the court shall not initiate any like proceedings of arrest against president and governor during the term of their office. And the third one is, the criminal proceedings shall not be continued against president and governor during the term of their office. Fourth one is, civil proceedings cannot be initiated against the president and governor during the term of their office in their official capacity, but it can be done after providing 2 months notice. So after providing 2 months notice, it can be initiated. Okay, this is the benefits that president and governor will enjoy. Now, the other exceptions are, no person is liable to any court for publishing true report on the proceedings of parliament. Okay, the MP and MLA is not liable to any court's proceedings for anything said or voted by them in the legislature. Suppose if an MP belongs to BJP and he opposed any law passed by the BJP, then he is not liable to any court. Okay, Article 31C. What is Article 31C say? Which I will be discussing in the next coming videos. Article 31C says that any law which gives effect to directive principle, the socialistic principles of Article 39, Clause B and Clause C, shall not be declared void or unconstitutional on the ground that it infringes fundamental rights which are conferred by Article 14 and 19. That is, if a law is passed by the government or the state which infringes Article 14 and 19, then it can't be declared as void. It can't be declared as void if it is giving effect to 39 Clause B and Clause C. Okay, that is with respect to Article 14. I have covered each and everything which is present in Lakshmikant. If you like the video, please like, share and subscribe. I'll be discussing 15, 16, 17 and future topics in the next videos. I'll be covering geography and economics also. If you have any doubts, please let me know in the comments. Thank you.